Thank you very much, Madam Speaker. It's been a very, very, very long debate. However, I'll start first by clarifying one or two things. First, if government in the debate means the executive, I represent the executive here. If anybody has said something that you are either referring to the executive, that does not represent the executive. I am the one representing the government in the chamber here. So I table this bill on behalf of the executive, and that is the situation. The other minor clarification probably I also need to make is the CRC process, the money that went into it. Apart from, I think, 2 vehicles that were donated by UNDP, has been funded entirely by the government of the Gambia. So it's our money, it's our process, because we want to own it, and we don't want to be influenced as to the way we should be governed. Yes, we had a lot of transitional justice activities that are going on, which our development partners are assisting in that regard. But for the constitutional development process, government decided to own the process on behalf of Gambians. So this is important that we make this clarification. Constitutional making is a very serious process. It's not a joke at all. And I appreciate the seriousness that this assembly has accorded to this process. Democracy itself also is very complex. And I think these 3 days of debate have shown how complex democracy can be. It might not necessarily be the best system. It has its own bitter pills that sometimes you swallow alone. But we go for democracy because it is the only best form of government that we can apply at the moment. I think this quotation is related to what Winston Churchill have once said. But it might not give us what we want in the way we want it sometimes. So it's a process, it's complex, and the debate both inside the chamber here and outside is very high. But we cannot expect anything less, because this is an important exercise in our national history. Sometimes passions can be high, but justifiably so. A lot of issues have been raised. From my notes, I recorded statements and questions from 50 speakers, if my counting was right. It is my duty to provide you the responses and clarifications you sought. Some I will be able to do it. Some probably I'm not too sure whether you can get them readily available from me the way you ask them, because some questions are asking things that has to do with rationale, why something is in the act and why something is not in the act. The answers to some of those rationale-related questions are contained either in their report, because the report accompanies the draft to explain the reasoning behind some of the provisions. I'm not too sure how many of us would have read the report along with the draft, because the report is the explanatory note for some of the provisions that might not be clear to you. But that's one aspect. The other aspect is CRC's mandate continues until 1 month after Section 22 of their act, until 1 month after this bill has been tabled before you. So we mean they are still in place. Section 22, sub 2 of their act says this assembly can invite CRC commission members to attend your proceedings to offer explanations and clarifications, unquote. Clarification and explanation. There's a big question hanging over that, but probably I will bring that to the end of whatever of my responses, because whichever way the vote goes today, it is my duty to attempt to clarify to you what are the options after the vote do we have? Which way do we go? If we should vote yes at this stage, what are the options? If we should vote no at this stage, what are the options? I don't need to mention the threshold because the Honorable Speaker have repeated it at the beginning of almost the first two sessions, that we need 3/4 of your votes, and in either of the two readings, that's the second and the third reading. And the conjunction there under section 226 is "and." So which means you need the 3/4 support now and at the third reading. If you don't have it now, technically, by my own interpretation, it could mean the bill is dead today. But you can have it now. The bill can survive for a while. If you continue to disagree, you have your right to still extinguish this bill will still be reserved to the third reading. You can still kill it at the third reading if we are not able to get the 3/4 support at the third reading. So we need 3/4 approval now. We need a 3/4 approval at the third reading stage. But we need both of them. That's the catch here. We need the 3/4 at both levels. We cannot afford to miss it now. If we miss it now, it's done. If we get it now and miss it at the third reading, it means the bill will be dead, but at a later stage, at the third reading, when we cannot get it at that stage. So it's important we make those clarifications. For those of you who support the bill, I probably wouldn't have much to say in the interest of time, except just to thank you for the positives and the good things that make you support the bill. I think even in the normal rules of advocacy, I should divert my energy more to those who have asked questions and have made it clear that their votes are dependent on the answers that they are going to get. I've recorded every speaker by your constituency. You will excuse me if, from what you have said, I probably did not see anything, especially if you are supporting. Probably I'll just skip you and look at those areas that I believe had asked for clarifications. So, some people have raised just concerns, and because even among those who are supporting, the majority position is they are relying on a possible amendment at committee stage. Let's support. We equally have concerns, and we can take care of our concerns at the committee stage, and that is if it gets there. There is some very few who are saying let's approve it as it is, it goes to referendum, and if it succeeds, we can come back after its enactment for amendment. So I saw these two groups. There are some that are saying let's move to the next level, do any changes we want to do at that level, have it pass. So let's reach a compromise at that level. There is a particular group that said no, let's not touch it at all. Let's approve it now, approve it then, it goes to referendum. After it becomes the constitution, we will have the opportunity to come back and amend. I believe all these groups exist in the chamber here. Now, for those of you who are relying on a possible amendment at committee level, a question has persisted. Do we have the right to amend or do effect any changes? Some will say whether we can touch or we cannot touch the draft constitution at the committee level. We've been thinking along this. Some people, legally, let me just give you a legal answer. Technically, I don't know of any law that can forbid you from doing it. Because it is a legislation, it is introduced to you as a bill. So I do not know of any law that could say you cannot. So that is clear. And I'd rather stop there. Let me not go, because if once I start going into the moral aspect of it, whether you can touch it or not, that will be very subjective and it will be opening to so many debates. I will leave that at least for now. Legally, I do not see any law that can prevent you from amending or effecting changes at committee stage. The rest, probably, if we are lucky that it passes this stage, we can talk about that. Because we have to accept the fact that we are also learning in the process. A lot of you have alluded to the fact that this is the first time this kind of thing is happening. Our laws, were they adequately prepared for this kind of situation? And so on. So probably from our experience, we will develop our laws to deal with that. So for those of you asking that question, my answer would be yes, legally you can, and I don't think that will be wrong. Basse, I believe you are the first to make mention of the issue of you have concerns with citizenship. The text on citizenship are clear. I think those that are concerned is about whether we need to keep them or we need to change them. And I would not be able to offer justifications as to what we can keep at this stage. The question is, I will focus more on those who don't understand provisions and who require an explanation. So it appears those who have concerns about citizenship, it's not because they don't understand what is in the draft. It's because either they don't agree with it or they don't like it that way. So we will leave that for further discussion. You also made mention of the issue of the retrospective application of the term limit. It's a concern. It probably, that is the Schedule 4, that talks about the term of the incumbent will be deemed to be the first term of office under this constitution. And then if the incumbent should contest and win, then it means that term, that new term will be his second term. Now there's a big disagreement over this issue. The argument as to whether a law can be retrospective or not, generally the minority leader attempted to say something. That is, we are doing this promulgation under an existing constitution, which frowns as a general rule on promulgating laws that have a retrospective effect. But this issue is a gray area. It is a constitution. It is the CRC that says, because remember, whatever is in this draft constitution, they are telling us that is what the Gambian people said. So now it's left to you to make a decision as MPs, whether you are convinced by that or not. But of course, if you are convinced that that's what Gambians says, then the Gambians as a population are the supreme lawmakers. So if they say this is the law, it will be the law. If you don't agree with that position, which you are entitled to, then that is your position. So that will be my answer to that. Because the minority leader in fact flagged something, and which took my mind to something that I did not avert my mind to. We are making this under an existing constitution. Do we even face the threat of somebody not being happy with what we are doing and go to court? Because remember, this is being done under the 1997 Constitution, which has regulated your legislative powers, what you can do and what you cannot do, and whether you do it properly or you did not do it properly. So these are things that I will leave it at that for now, because the question has come over and over again. It's just a question of when should it begin. The question of separation of powers was also very popular. Whether presidential appointments should be subject to parliamentary approval or not. The decision, actually, that one too, is not a question of whether you understood or you don't understood. It is there. Do you consider it appropriate, or it is an excessive power given to one arm of government versus the other arm of government? That is a decision that you have to make. That I do not need to make any further clarification on that. Like I said, I will only clarify where the understanding is an issue. The issue of national languages have come. All of those things are issues that people want to see that are not properly adequately catered for. The issue of the judiciary. Whether or not judicial appointments should be subjected to parliamentary scrutiny, the risk of having that process politicized has been said. The budget of the judiciary, the seemingly or apparent preferential treatment according to judges. Now, in the report of the CRC, I'll just make a little clarification here, not on the text. The text is clear. You are either in support of it or you are against it. But the issue of judicial officers, there is something probably that I can clarify. If you are a judicial officer, if you are appointed as a judge, the draft is proposing that if you leave office, you cannot take any other paid job for the rest of your life. You cannot practice as a lawyer. A former judge cannot be allowed to go back to court as a private lawyer. This is the difference between them and others who are working in other areas. A former judge, when you retire, you don't do other legal service, you retire for good. So probably, this is one of the justifications of enhancing their retirement package, because they cannot be involved in any other legal gainful employment. Because our employment is, if I'm no more AG tomorrow, I just go open my office and I start going to court. If I was a judge, once I leave office, I don't go back to court to go and meet other lawyers that were appearing before me to go and appear with them before another judge. So as a result, when you leave office as a judge, you don't practice law again. And they also have a longer retirement age. I think you amended that here. Is it 70 now or 75? Something of that kind. So, but again, that issue is not ambiguous. It's a question of whether you agree with it or you don't agree with it. The issue of plagiarism is common. It has come up many times. Responses have been offered many times. So, the 1997 Constitution also have provisions that are almost literally lifted from Ghanaian Constitution. Because the chairperson of that commission was also Ghanaian. So we were learning from the Ghana's 1990 or 92 Constitution at the time. It is not new in constitutional drafting. Or in legislative drafting in general, not only constitutional drafting, legislative drafting in general, to borrow clauses from existing laws. To what extent you are happy or you're not happy with that, I leave that to you. My role is only to offer explanation where I can. Honorable member for Serekunda posed challenges and questions on, for instance, how do we marry Section 102, Section 226? Is IEC ready for a referendum within the next 6 months? Now, we are working on the elections bill. It's ready. Whether or not this constitution passes, we are already working with the Office of the Speaker and the Clerk, where, if it is necessary, we will convene an extraordinary session of this House, hopefully next month, for you to consider the elections bill, because it is important. That is what is going to help the IEC to conduct the next elections. And we had the President said in his statement, in the State of the Nation's address, that the elections calendar will remain intact. Elections will be held on time. And as we are his assistants, we want to make sure that happens. The current electoral laws, we all know the state in which they are requires a lot of revision. So a brand new bill has been drafted. I believe some political parties have already received invitations for a validation workshop. So after that validation, we would bring it here. So we believe if we have to wait for a December session, probably that will be late. So we want to bring it even if it requires an extraordinary session, at least for that bill alone, so that we deal with that. So the question whether IEC is ready, we believe we will do what we can to support them. Let me put it that way. We will do what we can to support them to make sure they keep up to their calendar. If it requires their legislation being in place and other things, we will be supporting that. So they should be able to hold their registrations and conduct the referendum, hopefully on time. The other promulgation issues that Honorable raised, I will leave that when I'm discussing my options, because they pose questions that are a little bit challenging. Honorable Serekunda is one of those who are of the view we pass it the way it is. If we are not happy, we can always have an opportunity to amend subsequently later. Now, this issue of the validity of the Constitution under the constitutional supremacy.
To take anything, but I would rather, as we were doing before, allow him, and then if he has omitted anything or misquoted, then you will come on board. Otherwise, everybody who is misquoted will come in. I think you just note it at the end.
Thank you. I will minimize quoting members, in fact, because I might wrongly quote somebody, and then that person will be duty bound to clarify. All right. Thank you. The issue of validity of the Constitution. My understanding of it, and the issue is still debatable, but my take is when you say the validity of the Constitution cannot be challenged in any court, to me that is different from saying the validity of the provisions of the Constitution cannot be challenged. Right? If you cannot challenge the validity of the Constitution, that is to say, in my view, once the Constitution goes through all the process and it is completed, the Constitution as a document, you cannot challenge its validity because it's already endorsed and it has gone through the promulgation process to the end. Notwithstanding, the provisions of the Constitution can be violated, that can continue to go to court. If you National Assembly should pass a bill and you pass it without following the due process as prescribed in the Constitution, of course that can go to court. So, to me the two are different, but this is law. I try to humble up to say people can interpret it differently. But that is my take of it, that is my impression of that provision. You say the validity and the legality of the Constitution cannot be questioned before a court of law. My take is, once the Constitution becomes the Constitution, you cannot go to court and invalidate it. Because the question that begs is, against what instrument you're going to invalidate it? Because if you want to declare something invalid, you measure it against something. If you want to see whether an act of parliament is valid or not valid, you measure it against the Constitution. But if you want to determine whether a constitution is valid or not valid, you are going to measure it against what? But then, does that also mean, let me be very, because it's my duty to clarify, and I have to respect opinions on both sides and clarify as much as I can. Could it by extension mean, how about if somebody wants to challenge the process leading to the processes of the promulgation? That could be an issue. Like, after the Constitution is passed, somebody believed that the process was flawed. Therefore, because of the flaw of the process, it is invalid, you want to challenge it. Could we see this as a bar to that process or that right to go to court to challenge that? That's something else. Because I understand different lawyers are giving this issue a different interpretation. Right? So I would not claim that my own interpretation of it is the only correct one. Because I'm seeing that dimension also. The process that led to the confirmation of the Constitution, could somebody have the right to challenge whether that process itself was valid? Because if that process is invalid, then the Constitution itself will be invalid. So, can I go to court after the referendum and say something went wrong during the journey of the promulgation, and therefore this Constitution is invalid? And would this provision be robbing me of that right to do that? Some lawyers might look at it from that angle. But again, this is it. So that's it for the validity. The issue of election of a speaker, I have looked at it myself. Probably these are the areas where, if we succeed in getting to committee level, all of us would require some clarification. Yes, I did not see the procedure of it. It provides that the speaker can be elected from outside of the parliament. How it happens, I did not see it, and I see the concerns of members who are raising that issue. So a lot of issues are repetitive. Appointment of CJ, confirmation, with respect to whether different judges have given the different appointment procedure. Like I said, those ones are very clear. It's either we say, yes, we want our judges appointed and be subject to confirmation proceeding, along with all the risk that it goes with, or we don't want it, let's remove it. But that one requires no further explanation because the text is clear in itself. Now, the issue of secularism. The word probably might not have come, but religious freedom and the protection of our rights to any religion and opinion is guaranteed at different parts of the draft constitution. And I think the provision in the 1997 constitution have been repeated in the draft that Parliament cannot have a right to declare Gambia a religious state or a one-party state and goes that way. Somebody asked specifically the addition of the word opinion to that right, what would it mean? But it's just the word itself. You have a right to form an opinion about somebody, and you cannot commit an offense by having an opinion about something. Basically, that's what is it. The changing of the name of the IEC, the issue of the safe holu, the tenure of office, many speakers, even those that are in support, said there should be a tenure for the safe holu. They are not happy that they are elected and they remain in office for life. The power of the National Assembly to review budgets, especially the budget of the judiciary and some of the independent institutions. Like I said, these are all things, if we succeed in getting to committee level, whether we can do a trade-off, I will address that towards the end of my submissions. So they keep coming, cabinet appointment and so on. The validity came again. The financial allocations to the judiciary has caused a lot of alarm. Now, the honorable nominated member, it was unfortunate that the translated or the recorded versions of the Constitution were not made available to her before the introduction of the bill. But the CRC actually did translate the draft constitution into different languages and in audios. But I think the distribution was not done on time for the honorable nominated member. But I believe after your intervention, they should have provided you now with the audio version so that you don't have to get to somebody to help you to read it. So like I said, I'm seeing so many comments, but even for those that are objecting, some of the comments are generally not because those that are in disagreement don't like, they don't understand the provision, they understood them, they just don't agree with them. And for that one, I don't want to take much of time to deal with that. Your right to agree and disagree with the provisions of the draft constitution is yours. It's only where I can offer some explanation to clarify that I will try to give. The issue of secular has been a concern. Yes, the word has not been there. Honorable Member for Banjul said it would have been better it is there. The word have been avoided. And I think in the explanatory note they said They gave reason, whether you're satisfied with that or not, but they said they have catered for protection of all religions. The immunity of the NAMs not adequate. Now, Honorable Member for Banjul North raised an issue that caught my attention. That is to do with whether the transparency of continuous voter registration. But I think that is an operational matter. Maybe an act of parliament, or probably when we bring the elections bill, whether it is going to be transparent enough. Instead of periodic registration, we now, in the draft constitution, it is proposed for continuous registration. Like anytime somebody reaches 18, you can walk into any IEC office and get yourself registered and be placed on the election database. I understand your concern, but I think that can be addressed when we bring the elections bill, because that will be an operational issue. Issues that I have offered little explanation, I would not repeat them in the interest of time with my people. There is a member, I think it's Jarol, that said in the event of a tie in a second round, what happens? Yes, I tried to look for the answer. I couldn't find it. I don't know whether the draft have addressed that. What the draft addressed is, if we go for presidential election, the first round, the first and the second will go for the second round. If there is more than one person that has a tie, they can all go for the second round unless one of them withdraws, or any one of them withdraws. But your question is very pertinent. What happens if we go for the second round? The second round itself, the two people that are going for the second round get a tie. Exactly the same number of votes. How do we decide who becomes the president? All right? It appears the draft have not addressed that. And as long as we are dealing with numbers, that is a possibility. It is a real possibility. So, and I think that is something that I also noted. So it's a good observation. Many people are saying some issues were raised during consultations. They are not reflected. I don't think I can offer explanations for that. Their report tried to explain. And from what I read from the report that accompanied the draft, except in few instances, like somebody validly argued about citizenship where they acknowledge overwhelming number of people they consulted suggested a particular form of citizenship, I think like automatic birthright to become a citizen, when they put in something different. And I think a couple of, maybe just few other areas where they departed. The rest, the CRC submission is they followed the public view. I respect the position of the minority leader, who said we need to see the statistics to confirm whether they did or they did not. That's something else altogether. But we can I can rely on the report submitted by the CRC. Okay, I think one other hot issue during the debate was the provision on marriage, right to marry. I think it came up in a couple of submissions. Now, again, if I read 1997 compared to the draft on the issue of marriage, because some members specifically asked that I explain, because they don't want to vote in for a document that will indirectly legalize gay marriage, because that's the whole major concern, I think, about the definition of marriage. Now, the 1997 Constitution, Section 27 said men and women of full age and capacity. And the CRC repeated exactly the same provision in their first draft, and there was a lot of noise. So in the second draft, now they changed it and said a man and a woman. So the question posed to me is, I don't know if I will rephrase your question, which one of these two provisions is gay friendly? Or it has the risk of gay people using that provision and justify? My interpretation of a man and a woman, let me get the actual. It said a man and a woman of full age and capacity have the right to marry and found a family. Some people said they've spoken to lawyers who told them this is a gray area. So I can only answer you to the extent of my understanding of the law, and that means other lawyers can understand it better than I do. And that's the beauty of law. That's why we hustle all the time in the court. I'll make a submission, somebody makes a different submission, and the judge is there to agree or disagree with one of you. If you say a man and a woman of full age and capacity have the right to marry, my take of that is a man and a woman with the conjunction. It doesn't provide for two men to marry. A man and a woman. But somebody broke this down and said, another lawyer said the word "and" there can, I don't know. If I have to interpret it with all my legal knowledge, a man and a woman of full age and capacity have the right to marry. Under that provision, my interpretation is no two men or no two women can rely on this to marry. For the marriage to be valid under this provision, it must be a man and a woman. It cannot be a man and a man, because it's not saying that. It did not say a man and a man. It did not say a woman and a woman. It was a man and a woman. And in legislative drafting, when you have "and," it means the two parts that the "and" is joining are inseparable. That is the technicality there that I know. But if another lawyer is saying, under this, gays can marry, that is not my understanding. And I can only clarify it to the extent of my knowledge. So, that is my response to that one, with issue of marriage. But then somebody said, one of the commentators said, why don't we clear the doubts and just make a provision specifically to say gay marriage is prohibited in the Gambia? I heard that from somebody making a comment of that kind. Again, is this something we can consider when we get to committee stage? But whether we get there or not, that is something else, like I said, I will address at the end of my submission. There was a member that commented issue of right to property versus, is it the rights of the thieves to steal your property? What do you do? There was a submission along that line. But your right to property includes your right to defend that property. So the right of self-defense includes your right to legitimately defend your property. So nobody would say that you can sit idly and watch somebody steal your property. But I think where the person is trying to talk about is too many, maybe the rights of, too many rights are given to, I don't think specific rights are given to thieves in any law. What probably is maybe the human rights threshold is too high for him but that is it. If you catch somebody or anybody that is suspected of committing an offense, including an offense of theft, the proper thing to do is to hand the person over to the police. So if the question is trying to say, I am prevented from dealing with the person personally, if you are allowed to deal with them personally, then we'll be taking the law in our own hands. I understand losing your property, valuables to thieves, is painful, but as a society we agree that we have a system that the law will deal with them instead of us dealing with them personally. So the issue of judiciary budget, their retirement benefits kept coming almost every people, even those who are in support are not happy with that. So, and I don't want to defend it too far so that it looks like another lawyer is defending their proposal. But I took note of some comments, one or two comments, which probably could be taken into consideration. Someone said the budget we approve for you in a given year may be based on certain considerations. Those considerations may not be continuing events into the subsequent year. So if you tell me that the budget you gave me last year, I cannot touch it the subsequent year, I see that argument when the person was making a submission. Like if you are to build institutions, you are to buy vehicles and certain expensive, your budget might go up in that given year. So the person is trying to argue, if the subsequent year you are no longer building or buying those fixed assets and those kind of assets, would it be justifiable to say, okay, last year you gave me 100 million, so this year you cannot give me less than 100 million. So when that one came, I say, okay, there is something coming up there. But that is what is there. We will see whether this is something that can be. Nominated member Jaite made an extensive submission. I will not be able to repeat some of them. You know, some of the statements that some of you make, you are the only ones who can make them. I cannot make them here. But she raised some pertinent issues regarding if the Constitution doesn't go through, the implication of that. And she's in agreement with the affirmative actions that are provisions in the draft Constitution, the broadening and expansion of the autonomy of local governance and so on. So like I said, those that are in support, we cannot say much. There is a question asked whether, if I'm getting it right, I said I will avoid quoting, but if I'm getting it right, whether if we should change anything in this draft, would be duty bound in order to do that changes to go back to the citizenry. I don't have a straight answer to that for now, but I'll try to look at the options. List. Thank you. One of the innovations cited by Wuli East is private prosecution, but it's only made elaborate, but there is private prosecution provided for in the 1997 Constitution. Section 86 dealt with that of the 97 Constitution. So probably they just expanded it, but there is room for private prosecution under the 97 Constitution. Of course, you made mention of the high threshold at the referendum. The same, we are facing a very high threshold even in the House here as well. And equally, another monumental threshold at the referendum is a difficult task, but that is it. So. There was a specific question from Busumbala, whether female circumcision. Under the rights of the children, the word, I don't think the word female or the phrase female circumcision is used. But they are protected from all kind of physical harm and other things. So it depends on how you look at it. So children are protected from exposure to any physical or moral hazard. So that's what I can offer. But the word female circumcision, I don't think that has been used. I think it's the same Busumbala, the youth section 84G, the 10% allocation of rights to youth not entrenched, that is correct. I can confirm, yes, that paragraph is not entrenched. The issue raised about pardoned convicts can contest elections and the disparity between that and dismissal or termination. That is how it is stated in the Act, the draft. So it is there like that. If you are convicted and you receive a pardon, you're qualified. If there is a provision, I think Section 27, Section 27, no, not 27, 1 second. It's not 27, 27 is dealing with some other issues that are raised. But yes, there is a provision, if I get the section before I conclude, I'll let you have it, which provides that when you are terminated or dismissed from the public service, you can be disqualified. Concerns about impeachment of president made easier than removal of a high court judge. Like I said, these are not issues that border on misunderstanding. These are issues as to whether I agree or I don't agree. All right? So I will leave those ones entirely to you. You form your opinion as to whether you agree or you don't agree. It's not a question whether I need to add a clarification. They are exactly the way you see them. So you can form your opinion based on the way they are. The member for Talinme raised a very pertinent issue. I didn't have time to avert my mind to read clearly, but he raised, I don't know, I think whether she was quoting, I don't know whether it's the 97 Constitution or this issue of prohibition of amending any electoral law 9 months prior to subsequent election. I think that was calling us to something. If I married that to the honorable member for Serekunda saying whether we are ready to go to referendum on the stated date, this we will look at it and advise ourselves adequately on that. I didn't have the time to consult on it and look at it. But it's something we've noted. Now, the issue of 48 hours detention powers given to law enforcement versus 72 hours. I think this is Section 39. Section 39(4). Is it? Yes. Section 39(4), paragraph F. Yes, 48 hours is what they have provided there instead of 72 hours that is in the 1997 Constitution. And the caveat there, the consolation there is they're saying if the 48 hours falls on a day that is not a court day, then the right to detain the suspect will be extended until the next available court day. So assuming, my take would be if you are arrested on a Friday, if you are arrested on a Thursday, the 48 hours falls on a Saturday. It's a non-court day. Sunday is a non-court day. So the next legally acceptable day that you can be brought before a court of law would be on a Monday. So technically that's what it means. So the 72 hours versus 48 hours, but they said if the 48-hour falls on a non-court day, then it can be carried forward to the next available court day. Now, the issue of restricting public servants, that is true. That is what is in Section 27. Restriction on the activities of public officers. The only thing I can add there is, he said, except where an act of National Assembly may provide otherwise. But yes, those that are objecting to that provision, that is what is there. We cannot deny the obvious that is stated. It says a full-time public officer in the service of the state shall not engage in any gainful employment unless exempted by an act of parliament. So that is the provision. So if exemptions have to be, then the House have to legislate and give exemptions. Otherwise, all public servants are going to be prohibited from taking any other gainful employment. There is a request for clarification as to what type of pardon. Is it conditional or unconditional pardon are we providing for? I wouldn't be able to distinguish the pardon, but the pardon that this constitution is granting is pardon sufficient enough to allow you to take public office, where otherwise, if it not for the pardon, you could not have gotten the right. So basically, it's a pardon once it is granted to you. If, for example, your criminal conviction could have been a bar for you for a number of years from attaining or assuming certain public office, the pardon that is proposed in this draft constitution serves as an exemption to that. I don't know how you will categorize that kind of pardon, because whether or not the pardon will erase the criminal record as if you were never convicted, that is an issue of debate even among us lawyers. Whether a pardon is sufficient enough to give you a respite from serving your term, or whether it deletes your criminal record or not. These are issues that people have different opinion. But what is provided for in the draft constitution is, if you get a pardon, then it serves as a waiver from the criminal record being a factor against you gaining something. So basically it removes it. Some of the members were so passionate about the apparent bias towards the judiciary. And they say, what is so special about judges? When everything goes wrong in society, you come to us. That is what makes the judges special. You know, when everything else when all hopes are dashed, we only rely on the judiciary. So, but then that doesn't mean we are more important than other sectors of society. But we need to, on a more serious note, we need to give judges much more security. And we are trying to encourage Gambianizing the bench. So it's important that you make the position not only secure, but you make it attractive. Attractive for the other reason of making it attractive, so that they are not susceptible to being corrupted. I mean, the courts deal with all sorts of things. They deal with liberty of men and women, but they preside over commercial cases that will cost millions, if not billions. Now, if you don't give them a condition of service that makes them a little bit more comfortable, then they become very, very susceptible to other issues. So this is why it's a standard worldwide. I have checked in Nigeria and Ghana. You will see that the same principle that this draft is proposing is what is in the Ghana constitution, is what is in the Nigerian constitution. The only difference is our judges retire, I think, a little bit later. I think in Nigeria they retire at 65, and in Ghana around 60 or so. But they all retire with their full package. And their retirement package adjusts as the salaries adjusted. But that one too, I don't think is new, unless I'm getting it wrong. Even in normal public service, your retirement pay changes when salary scales changes. The pensioners, they get an increment when everybody gets an increment. Is that not normal? That is normal. Well, okay, I will leave it at that. All right, in our case, we're saying they go with their salary and allowances and everything. But actually, that is exactly the way it is provided for in other Commonwealth jurisdictions. Of course, this is Gambia. It is now for you to decide. The CRC have made a proposal. That is why it is called a draft. So it is for this House, and subsequently, if it goes through, for the Gambian population to decide. Some people said a lot of comments, like I said, but some of those things would not require my immediate response. We can only talk about those things if we happen to get to committee level. That is when we can look at those things, whether these are things we can cater for or not. This includes, some people have caused concerns about legislating or providing regulations as to how political parties themselves operate. And that is to say, the democratic principles that we envisage in the way the state matters are managed should be extended to the political parties, because they are institutions that are preparing to take over the state. So as a result, if you want a democratic state, let's extend the same democratic principles to the way and manner the political parties themselves are managed. That is in the draft. Whether this is a matter for a constitution or is a matter for another legislation, like I said, this is not sufficient for me to respond to that now. If we should get to committee level, these are all proposals that whether or not we can accommodate them, we will get to those questions when we get there. You know, the way your standing orders are and the way the Constitution is also framed, that is the 1997 Constitution, this process is a bit complicated and it's difficult, because we cannot do any changes at this stage. we have to get to another stage where we can even determine whether we should change or we should not change. And a vote need to be taken at this stage. So that makes the matter a little bit more complex. I don't know. I think this, well, the member will know himself when I mention it. Somebody made mention of, I've got your name, but the issue of national days. He has a concern in us describing them as national days. He said, apart from the exact day in 1965, the rest are anniversaries. It sounded interesting to me, and so it's something that one can look into, but it sounded new to me, and that's okay. If that is the correct position, of course, we will see what we do. Appointment of IEC members. All treaties and bilaterals must be ratified by the National Assembly. I'm not too sure, but I don't think they departed from that. That has been a culture. So somebody raised that concern, but I think that is still the situation. At least one thing I know is when it comes to treaties that that are legal in nature, our courts cannot enforce them unless they are domesticated. For at least now, it is clear in this draft. Before, in the 1997 Constitution, we were mainly relying on the common law principle, that common law countries don't automatically apply international treaties in their courts unless and until they are domesticated. Now, it is specifically stated in the draft that it has to be domesticated before the courts can apply it. However, the courts can rely on them for persuasive purposes, just for them to get persuaded. The use of may and shall, that's a question of language, so that can be looked into internal upper age limit. The issue of upper age limit has also been mentioned. It's not provided for. And one member strongly argued that this was the views of the people. For one reason, CRC in their report, they stated that because they don't find a common ground as to what that age should be. As a result, they abandon it. So a member is strongly arguing that once you have a lower age limit for qualification as a president, there is a requirement you have an upper age limit. The issue of citizenship. Some people are very comfortable with automatic birthright, but some people have reservations about automatic birthright. So opinions are a little bit divided on that. Excessive powers given to the National Assembly. Minority Leader, I think I'm getting there now. Minority Leader made mention of, you gave us a perspective of your consultation regarding the issue of validity, but I think my answer is clear. My understanding is slightly different from that understanding, but I'm not claiming I am right. Okay? But that is my understanding of that provision. So probably it would require some further clarification. And like I said, this is why there is a provision for the members to stay in office on 1 month after the tabling. You made mention of some discriminatory clauses, which are difficult to argue against. The different mode of appointment of judges. If they are all judges, why subject them to different mode of appointment? You are also among those who are not happy with the retirement benefits. Discrimination against the current president. If any other person wins, that person gets 2 terms under this constitution. And if the current wins, he has 1 term under this constitution. Well, that is it. Said the impeachment of the president has been too simplified. That is half of the National Assembly. Okay. That is correct. You specifically asked me to clarify Section 102C. (2C). To alter the decision or judgment of a court in any proceeding to prejudice of any party of those proceedings, deprive a person retrospectively of a vested or acquired right. Or this is your power not to be able to legislate and deny somebody of a vested right. This is Section 100, paragraph 2, which says National Assembly shall not pass the bill to alter the decision or judgment of a court in any proceedings to the prejudice of any party to those proceedings, or to deprive any person retroactively of vested or acquired rights. Well, the rest is saying is the exemption. It says, but subject thereto, the National Assembly may pass bills designed to have retroactive effect. I don't know, for those of you who follow, I think it is the, we have a case, the Usman Sabali case that we usually quote in the Supreme Court. And the 2001 amendments that were done to the 1997 Constitution. This particular paragraph was interrogated extensively by the Supreme Court of the Gambia. Now, I think the student demonstration was 2000. It was 2000. And I think the then government came to Parliament to try to amend the Indemnity Act to cover security forces that participated in suppression of that riot. But to summarize, at the time the amendment was attempted in the Parliament here, Usman Sabali was already in the court seeking compensations for some of the things, for some encounters that he has had with the security forces during that riot. Now, if you indemnify the security forces, the amendment happened after the fact. The amendment came to the House after the riot had already happened. So you come to amend the legislation and then to say that all the security forces that participated in the suppression of that riot cannot be sued, or you cannot even claim something against government, something to that effect. The amendment was passed. And then the government want to rely on that amendment to discontinue an already existing suit that was in the High Court. They applied to the judge for the judge to throw away that case because Parliament have just amended the law So this suit is no longer good enough to stay in court. And then the lawyer in the matter said, no. The Constitution in section 100, 2C, have barred Parliament to make any law that can go backward to remove a right that already existed, that I have already acquired. So, but under the 1997 Constitution, that is an interpretative issue. So the High Court could not do that, so the matter was referred to the Supreme Court, and the Supreme Court agreed and said the Parliament's amendment was null and void to that effect. So the case must continue, because the guy was already in court enjoying a right to sue. So you cannot go to Parliament and change the law and now come back to him and say your right to sue does no longer exist. So that much I can say to explain that provision. I hope that explains. That's the context I can give, because that is the celebrated case with respect to this particular section of the Constitution. Minority Leader makes some issues. I think when you made mention of this section, that is where you are saying, let us be careful so that we are not taking, but the issue of whether CRC should provide the statistics as evidence or proof that what they wrote is the views of the people, well, you are parliamentarians. You can ask for anything to help you to reach your conclusion. But they provided us a report, and they have quoted their statistics in their reports. If you want the statistics itself, if you get to a level where all these documents can be called and be interrogated, of course, yes. I have nothing to that. My problem and concern at the moment here as the mover is whether I'm going to get to that level or not. That is my headache at the moment. Honorable Deputy Speaker, we appreciate your comments and support. Majority Leader, equally. I don't see much issues that are raised that would require, like I said, those who are in support, we have no problem with that. So, this brings me to my final conclusions. Like I said earlier, as the Attorney General and Minister of Justice, the only thing I can do is to show utmost respect to both sides of the debate. You are only exercising your rights, and I did what I can do to offer you clarifications. It is your right to approve. It is your right to reject. That is the law. Whichever way you should decide, what options do we have? If we get a yes vote at this stage, you all know the bill moves to the next stage. At that stage, CRC members can be invited. They are still in office, like I said, by operation of law. And they can offer even better clarifications and explanations than I attempted to do now. This is provided for under Section 22(2) of their Act. However, the difficulty is whether if you want it amended at that stage, that is, if we have to amend it, who is going to do the amendment? Because the CRC have done their job and they have submitted their report. So, would the CRC be able to go back to this document and try to do another work? That is a gray area for now. But they can be invited. But the law said when they are invited, they can only give you clarification and explanation. It did not say they can change. And that is the act that you have passed. Clarification and explanation. I can read it for your convenience. Section 22(2) says, during the period prior to enactment by the National Assembly of the bill introducing the Constitution, members of the Commission may be requested to attend before the National Assembly to clarify any matter and answer any question relating to the provisions of the Constitution. And quite a number of you, even those in support of the bill, are talking about amending at committee level. Now, who does the amendment? It's a gray area. These are things that we need to look at. My office have a drafting department. We draft our bills that we bring to you. Will we be the ones that will be the amendment and things like that? This remains an issue. That is why I said, my ministry, on behalf of the government, we are the ones that tabled the bill. If it gets to a point when Parliament insists that they will have to change something, of course, then it is our ministry that will have to change. But all that goes with that is something we need to have at our mind to read. But like I answered that question earlier, that whether you can change or not, there is no law known to me that can forbid you from changing. Now, whatever happens, I'm still dealing with the first question. If we get a yes vote at this stage. If we get to that level, hopefully invite CRC members to offer clarification and explanations. Whether or not changes are done, the bill will ultimately have to come back to you. And when it comes back, we will require the same threshold to get it to pass to go to referendum. So you will have a second bite. That is irrespective of whether we change something or we don't change something. The bill will still come back and we will still require another 3/4 support from you in order for it then to be able to be sent to IEC for referendum. So this is it. Do we go there? And if you go there, what do we do there? Are we going to change, or are we going to only seek for clarification and come back? That is your determination. Now, of course, the flip side is, if we get a no answer at this stage, a no vote, by my own interpretation of Section 226 of the current Constitution, and I intimated earlier, a no answer at this stage kills the bill right here. That is my interpretation. Because both 2262 and 2264, 2264 is dealing with entrenched clauses. 2262 dealing with ordinary amendment. Either way, you still need 3/4 support twice. You still need 3/4 support twice. You need it at second reading, you need it at third reading. If you miss one of them, my own take is, it's dead. And for me, for this activity that we are invoking both 2262 and 2264. We are invoking both of them because we are repealing. It's a complete repeal. So basically, both entrenched and non-entrenched clauses are all going. We are flushing everything out and replacing them with something new. But either way, even if you said we are only invoking 2264, the wording is very clear. The bill is supported on the second and third reading. So it's very clear. Supported on the second and third reading by votes of not less than 3/4 of all the members. So if you get less than 3/4 at the first reading, is there even need to go to the third reading? Because you have failed to meet the minimum threshold. If I am correct, if the no answer means that the bill is finished today, so what? We are then left with the 1997 Constitution. That is the Constitution of the Republic of the Gambia, 1997. The only other option in addition to that, which is worth thinking, but we are not exploring at the moment because we are optimistic, is this draft will have to go back to the drawing board and we have a second attempt. If you completely reject it and do not allow it to go to committee for consideration, then basically you're telling us go back and redo it. If you want to come back, you come back. But for now, go back. But by sending us back with the bill means we continue to operate with the Constitution of the Republic of the Gambia, 1997. In those words, I leave it to you now. Thank you very much.
Thank you very much, Honorable. Earlier on, at the commencement of your response, Honorable Sala wanted to raise an issue, but I said I thought it was better to allow you to complete, and then some other honorable members may wish to seek further clarification. But we're not opening the debate again. Please, honorable members, it's just on points that have not been clarified. You will also agree with me that the honorable minister did respond on the legal issues. The opinions, whether you like A or B, he has clearly indicated it's left to honorable members.
Yeah. Point of order.
But the legal issues he has responded to. So
point of
we
order.
can take some
order.
Honorable, can you allow me please to land? Thank you. We will take some further clarification so that before we go to the next stage. It was Honorable Sala who first raised his tag. But can you just allow me? I'll come back to you. Actually, I'm being guided that probably we're deviating, but I said it's not a deviation because we've done it earlier that, after the response of a minister, some honorable members may feel that there are areas of concern, have not been touched. And then the honorable minister. No, not new issues. They are not new issues. The areas that have not been responded to, they are not new issues. The issues have already been dealt with. So that is why I said, let me hear Honorable Member for Serekunda, and then I will. Very clear, no new issues. There are areas that have already been raised, issues that have been raised, and you feel that the Honorable Minister has not covered them. But as I said also, the Honorable Minister has touched on, he told us that he would respond on legal issues. The opinions, he will leave to honorable members. Thank you.
Thank you very much, Honorable Speaker. The key issue is the position I expressed that due to the two elements in 226, where we have entrenched and non-entrenched clauses being considered in the bill, that we must address the two issues, because the entrenched ones we cannot touch. We must submit to the IEC for a referendum. The non-entrenched ones we can touch, because that is our mandate. We can actually amend, just like we've amended all these constitutional provisions, which in fact the upper age limit, it is this parliament that removed it. So this is how powerful this parliament is. So I'm saying then, what do we do under the current circumstances? And this is where I said that, well, looking at the act which mandates the CRC to prepare a draft constitution and submit it, and that has been done. That is in the schedule now. What they have submitted has not been touched. And the anticipation is that this is what goes to a referendum. So if we start touching on those provisions that are not entrenched, the procedure there is that once we pass the bill, it should go to the president for assent. So bills that are not entrenched would be passed by the National Assembly and taken to the president for assent. And if the president rejects and sends it back, then by force we must go to a referendum on those ones. That's what I was trying to clarify, the technicality. And the ones...
Sorry, before you respond, Honorable Minister. Honorable Member, your microphone. Yes, thank you very much. Unfortunately, I was not on the chair when you made your intervention, and the Hansard records are still not out. But I just want to confirm that these are issues, what you have just said are issues that were raised during your intervention, and that the Honorable Minister has not responded adequately to them. Because if not, it would amount to new issues being raised. As I said, I was not on the chair, and the Hansard records are not ready. So I just need confirmation from you that what you have just stated are issues that you raised during your first intervention, and the issues have not been addressed by the Honorable Minister.
Thank you very much, Honorable Speaker. Precisely so, that those are the elements which I had raised and indicated that since the work was done by the CRC in the committee stage, we'll have to have them there, have the mover there, so that whatever may be suggested must be something that they know is the mind of the population, and in that regard, may those that we add that whatever, and it is only those things that they approve that ultimately will come by way of amendment to those.
Sorry, you have just said it. I just wanted confirmation from you, but you've already said it, so I take your word. The Honorable Minister was here, and he listened to your first intervention.
Yes.
So if what you have repeated just now is what was said earlier on and has not been adequately captured, then allow him to touch on it.
Yes,
you already made your clarification, and he started responding, but then I interrupted, wanting to confirm that this is what was said.
Yes.
So I don't think there is any need for it to be repeated again.
No, it is not repeating, Honorable Speaker. It is simply stating what needs to be clarified, and that what I was saying is that I am not saying it should not be touched. I am saying it could be, especially if the provisions deal with the non-entrenched ones, but the entrenched ones we cannot touch. That's what I'm saying.
Let's
We just
allow the
approve.
minister to respond.
And second element, I mentioned
Honorable.
88.5. I mentioned 88.5 that guarantees the element.
Honorable Member for Serekunda, with all due respect, you had already made your point.
No,
No, but the Honorable Minister was about to respond when I intervened, and I wanted to confirm that the issues that you had raised had been covered in intervention and not adequately captured in his response. And you confirmed yes. I say, well, in that case, the Honorable Minister can respond to the concerns that you have raised. I think we're speaking the same language.
Will you give me a second time? I'm saying the issues that I raised that he did not answer is what I just wanted to put quickly, and he will respond to them. He did not answer to those ones.
Let's make some progress. You can just paraphrase the issues,
Yes.
and then just one more chance, and then we
Precisely.
allow others. Yes,
Precisely. I'm saying 88.5 is the other element where the president can no longer declare any country as a country, a state based on religion. And I mentioned that is not entrenched. So we should think of entrenching that so that both the legislature and the executive will not have that authority. And I would want the Honorable Minister, I stood up when the member Fofoni Jarol mentioned the issue of the declaration of the winner. And he mentioned an element. It will be good for the minister to look at 98, because there are two declarations. Declaration in 97.1, if the person has 50% is declared, but then 98 is saying that the commission will declare a winner. So and I compared it with the 1997 Constitution 48, and you will see that yes, it is stated there, it envisages a tie, even though it's not dealing with the second round, but it envisages a tie and says that the person who has the highest number of votes will ultimately be declared a winner. Is it necessary to incorporate it, as the member for Fonjarol is saying, or could you also even have a tie again, of all the elements? Then what do you do? So I'm just saying, let's put that all into consideration and see how to handle this particular area.
Minister.
Thank you very much, Honorable Member for Serekunda. I see the clarifications from the Honorable Member as adding value to my responses. Probably those are gaps that I did not adequately cover. The area that I'm not very clear with is when you made mention, probably you would need to clarify for me again. When you mention areas that are entrenched, we can touch. Areas that are not entrenched, we probably may not be able to touch. Are you referring to the draft constitution, or because if it is the draft, nothing is entrenched yet because it's going through promulgation. All right? So there is no issue of what is entrenched and what is not entrenched. So that's a little clarification I may need to know before I proceed with it.
Honorable Speaker.
Can we proceed? Let me allow Honorable Member for Upper Fuladu, please.
The Honorable saying he wants clarification, Honorable Speaker.
Yeah, he has get passed. Okay.
Honorable Minister, this is the Constitution, the living document, the 1997 Constitution. The draft does not exist. And what we are now doing is to promulgate. And we have to rely on the powers we have under the 1997 Constitution to do that. So the powers we have is to amend entrenched clauses and non-entrenched clauses. But it indicates how we should do each and how we should actually amend non-entering clauses is there, and it's 4 onwards. And how we should amend non-entering clauses is there, 1 to 3. The non-entering clauses, if we amend, we can pass the bill, but it must go to the president for his assent. But the entering clauses, we approve, we do not pass. We approve, then it goes to the speaker and given to the IEC, and that's where the 6 months come. I don't want to go to the quotation, you'll be able to see. So it says within 6 months, the IEC must hold a referendum. And what I mentioned was that IEC is scheduling a referendum in June 2021. And if you look at the 6 months that is dictated by the Constitution, we will not be able to abide
Yes,
by it.
I think let's allow him to clarify. Otherwise, it will be
Now I understand.
extracted
But
on and on.
my take is, I don't think that is the situation we are dealing with. Because we do not have the luxury of identifying from this draft which part of the 1997 Constitution is it amending us to describe it entrenched, and which part of the draft is touching on the non-entrenched clauses of the 97. That would have been easier for me if we had brought an amendment bill to the 1997 Constitution and it covered different areas of the 1997 Constitution. Then this compromise can come. We can say, okay, the areas we can do now and send it for assent, let's split and remove those ones and deal with those, unless I'm not understanding you. And the areas that are entrenched, we deal with them separately. But for me, effectively, this repeals this other one completely. So the issue of how do we know from this draft which aspect of the 97, because it is not effectively amending it, it is completely repealing it. Yeah, so that's the difficulty here. There was, I think you made mention of 98, section 90, 97, 98 of.
The section for him.
Yes, I've noted them now.
885.
885 of the 1997. No, of the draft. Yes. The President shall.
Honorable Member for Serekunda, you referred to the relevant section. Can you just assist in quoting it so that we'll save time?
Well, he has it, okay. 88.5 is saying...
The President shall neither have nor exercise the power to establish one party.
88.5.
Yes.
Thank you.
You want to go ahead?
88.5. Thank you. Thank you, Honorable.
Just a moment, Honorable Speaker, just to cross-reference something. Section 48. Yeah, so the issue of the Thai situation can probably only be resolved when we get to that other level. Okay, is there any other?
Thank you, Honorable Member for Upper Fuladu.
Thank you, Madam Speaker. I rise on a point of order. I rise on a point of order. Point of order, yes.
A section or clause?
Yes, I'm quoting in the section 53B, D, and F. Clauses 53B, D, and 53. 53B, D, and F of the standing orders. Madam Speaker, the point is the Honourable Minister has done a good job in trying to clarify some of the issues that we have raised. but he has time and time again raised the issue that he doesn't think he's doing justice to some of the clarifications. And we are at a critical point where that could be determined by how much clarification we have. So therefore, I am of the view that we need the the CRC's support on informing us because the stakes are high. If we fail at this stage without getting the right information, that could affect our stance. So 53B is saying that the following motion may be made without notice, a motion for the adjournment of the assembly. D is saying a motion for the withdrawal of strangers. And F is saying that a motion for the assembly to resolve itself into a committee of the whole assembly.
Are you relying on
53B, D, and F. The reason why we want to invite the the CRC, to come in and support us in this particular decision.
Honorable, with all due respect, I will disallow that motion because it is not proper procedure. We are going by the dictates of the Constitution and we have gone this far. So let us finish this process and see what happens. But really, I don't think it is proper and fair at this point in time to adjourn. Unless we have Larikunda Saviji.
It's okay, man. Madam Speaker, I want to rise on the on Standing Order 53C. Yeah, you can adjourn. Yes. 53C, please. Yeah, motion to adjourn of a debate.
Honorable, I think I have made it clear, I've made a ruling that we're not going to adjourn. Let us finish this process and whatever happens afterwards, it's fine. I'm just taking clarifications from honorable members for the minister to clarify. Is it on clarification?
Yes.
Your area that has not been touched?
Yes.
Yes,
Honorable Speaker, I was not sure whether you were the one sitting, but I raised an issue that there is misunderstanding, misinformation going about. And even in this House, some people raise it. What is the position of the executive on the retroactive, the two-term limit? What is the position of the executive? You are I said you are the representative of the, and some people try to create misunderstanding around that. So we want to be so that nobody misrepresents the executive in this House. What is the position of the executive on that? Thank you.
I think there's a new issue. There is Honorable, we have also read the draft.
Madam Speaker.
There is no indication of an executive decision or whatever. So please.
He is not the executive, he is a member.
He is a member of the executive. Honorable member for Central Badibu, if it is on areas that you have touched and the Honorable Minister has not adequately responded, I will allow you. Otherwise, no.
Okay.
Okay, thank you.
Honorable Speaker, Section 100 of the Constitution, subsection C. I want the Minister, the Honorable Minister, to further explain, because to my own understanding, C allow us to make retroactive laws. Because if you look at C, it says to alter the decision or judgment of a court in any proceedings to the prejudice of any party to those proceedings or deprive any person retroactively of vested or acquired rights.
Oh, good.
But subject thereto, the National Assembly may pass bills designed to have retroactive effect.
May I ask, intervention, did you raise that issue?
Honorable Speaker, it was
Honorable, not only that, but I think it has been touched by other honorable members, and I think the honorable minister, in all fairness, did touch on the retroactive position of
Honorable Speaker.
So please, let us proceed. Members, no, sorry. The process, the honorable